Good afternoon and welcome to the latest installment of McAfee Taft's EmployerLINC webinar series. Today's presentation is entitled Wage and Hour Laws in Compliance, Out of Trouble. It will be 1 hour in duration, ending right around 1 o'clock Central Time. But before we get started, I'd like to point out a couple of items. First, this program has been submitted for 1 general recertification credit hour through the HR Certification Institute. Once we receive notification of the program's approval, we will send everyone who pre-registered for HRCI credit a follow-up email with program details. Second, you should see a Q&A tab near the top of your presentation screen. That Q&A tab allows you to submit questions electronically throughout today's presentation. Because of the amount of material to be covered today, there likely will not be enough time to address those questions during this hour. However, we will post answers to many of these questions by early next week on this webinar's webpage, which can be accessed in the events section of our website. We will also provide a link to that page when we send out our follow-up survey email. And now to today's topic. The number of wage and hour laws affecting employers is staggering, and with the Department of Labor stepping up its investigation and enforcement efforts, staying in compliance is critical to avoiding liability, including financial penalties and possible litigation. The DOL's Wage and Hour Division is paying closer attention to all aspects of an employee's work life, whether your employees are punching a time clock during a 40-hour work week, working overtime, telecommuting, being on call, donning and doffing special work equipment, traveling as part of their job, or any number of other scenarios. Today, our presenters are McAfee Taft employment attorneys Charlie Plumb and Paul Ross. They will help you gain a more thorough understanding of the Wage and Hour Division's role and authority, their new enforcement initiatives, and what employers can do to stay in compliance and out of trouble. Charlie?
Thanks, Brad, and good afternoon, Paul. We started this morning with ice fog, and now it's a beautiful day. And I can't think of a more exciting subject to talk about than wage and hour law. Now, I say that somewhat facetiously, but I think what we saw in the last half of 2011 and what we're hearing from Washington the first half of this year lets us know that we're going to have a busy time in the next 12 months as employers dealing with wage and hour issues. And what Paul and I wanted to accomplish today, if we could, is give you some idea of what's happening with the Wage and Hour Division and what focus on some particular subjects and issues we think Wage and Hour Division will be focusing on this year, really with an eye towards giving you some information to spot problems before they become bigger problems and solve them in advance. And I think the way to start with that is getting some understanding, basic understanding of what the Wage and Hour Division is up to and what we can glean from that. The Wage and Hour Division is part of the Department of Labor, and their responsibilities include administering and enforcing the Fair Labor Standards Act. Now, those responsibilities include interpreting that law, investigating complaints, conducting audits and investigations that Paul is going to talk about, and if they find violations, perhaps prosecuting those violations in legal actions or charges. A lot of what we're going to talk about today and what Paul covers in his section involving investigations and audits is going to involve what sort of record keeping you as employers need to keep in mind. One thing to think about is where has the Wage and Hour Division been going with enforcement actions and investigations. And there are some pretty startling statistics from 2007 to the present. When the Wage and Hour Division has been involved in enforcement actions, they have found violations on the part of employers 73% of the time. So that's not a great batting average for us. We also know since 2010 there have been over 25,000 complaints or contacts by employees or former employees with the Wage and Hour Division, again, aiming at triggering either charges or investigations or audits. And we have, in the last 12 months, 350 new field investigators whose basic responsibility is to be out there investigating complaints and determining whether employers are complying with the FLSA. So I think we can tell from these trends that we are facing a more active wage and hour division. There are also a number of new initiatives that are in place or getting ready to gear up that will trigger a lot more potential exposure for employers. If you go to the DOL.gov website and look up the We Can Help campaign, what you will find on that website from the Department of Labor is really a solicitation for wage and hour complaints. It's asking people to use a toll-free number. It's encouraging employees, former employees, or even third parties to contact the Department of Labor if they believe there has been a violation of the Fair Labor Standards Act, particularly overtime type issues. So the We Can Help campaign, which was rolled out late last year and is really up and running right now, and take a look at it at DOL.gov, it is a mechanism that I think will trigger more investigations and more complaints. There's also been the adoption of the Bridge to Justice program, and this is a partnership between the Wage and Hour Division of the Department of Labor and the Bar Association, and it really is a way in which if someone contacts the Wage and Hour Division about a potential violation of wage and hour overtime provisions, the Wage and Hour Division will put that potential plaintiff or complainant in touch with a local attorney. Again, something I think we can assume is going to increase the chances of charges or litigation resulting from violations or alleged violations of the FLSA. And I think many of you may have seen in the media, now there's available from Apple, the Apple App Store, a free download, and it's called DOL Timesheet. And that DOL Timesheet is intended to permit an employee to independently track the hours they're working, to note activities like lunches or breaks, and produce a summary of work hours and project gross pay. Now, another interesting feature of this new free app, DOL Timesheet, it also gives the user the ability to create an attachment of that information and email it directly to a local wage and hour office. So again, I think all these kinds of things are going to lead to whether it's We Can Help, Bridge to Justice, or an individual using that smartphone application, it increases the chances of employers in the next 12 months to be facing challenges on whether or not they're complying with the Fair Labor Standards Act. Those challenges may come from the Wage and Hour Division themselves, or it may come from private attorneys. And I'm going to turn to Paul to give us a little overview of what we should expect if and when a wage and hour investigation or audit comes to a particular employer's place of business.
Okay, thank you, Charlie, and good afternoon, everyone. I hope you're all having a good Valentine's Day. I'll tell you before I get started, I'm a little disappointed in my Valentine's Day because Charlie did not buy me flowers, or at least maybe I'm just waiting on the delivery. Maybe they haven't gotten here yet. But moving on, as Charlie mentioned, we're going to transition at this point and talk about really what are the two main enforcement mechanisms that are used to implement or enforce the Fair Labor Standards Act. And those are, number one, DOL audits done by the Wage and Hour Division itself, and number two, actual lawsuits and those private federal court claims that are brought either by the DOL or by the plaintiffs themselves. And we'll talk about both of those at length as we go forward today. I'll start by talking a little bit about wage and hour audits, and these are actual audits that are performed by the Department of Labor's wage and hour investigator force actually at the private employer's place of business. And these are administrative audits where the Fair Labor Standards Act issues are investigated and then hopefully resolved before a federal lawsuit comes up on these same topics. The kind of main point that I want to start with in talking about what to expect if you get a wage and hour audit is, number one, I want to make sure that we don't just talk about the Fair Labor Standards Act. The DOL and the Wage and Hour Division have the responsibility to enforce several laws, not just the Fair Labor Standards Act, and an audit could encompass not just wage and hour issues, but it could encompass FMLA issues. It could encompass immigration issues. It could encompass OSHA issues. Small parts of the OSHA Act are governed by the Wage and Hour Division and investigated by the Wage and Hour Division. Or it could cover polygraph issues if those are the types of, if you have subjected some of your employees to polygraph issues. So the scope of a DOL audit, wage and hour audit, may be far broader than what we're going to spend most of today talking about, which are the details of the FLSA. Next, though, let's talk about the actual wage and hour issues and how a complaint, a wage and hour type complaint, is typically initiated. Because most often an audit that is conducted by the DOL is a wage and hour audit. Most of the time what we see are complaints about overtime or complaints about uncompensated work time or complaints about those type of wage and hour issues. So how do they come about? Typically speaking, an audit is initiated by an employee or an ex-employee's complaint. The DOL will tell you that it does do random audits. It does do audits of specific industry sectors. It does do audits of specific geographies based on trends that in the data that they analyze and review. But for the most part, the substantial majority of audits that employers receive are prompted by a complaint of a jilted employee or ex-employee. Now, what you will find, and this is very often when we deal with these audits, the very first question I get from employers is, why me? Why is this audit happening to me? And the response is always the same as what I'm talking about here today. It is likely that you have an employee who has reported you for this concern. And, of course, the immediate follow-up question is, let's find out who it is. How do I find out who it is? And the answer is the Department of Labor Wage and Hour Division is not going to tell you. They won't tell you affirmatively that it's a complaint that has caused the audit. They will not tell you who the complaining employee is. Oftentimes I've found we can figure it out by the questions that are asked, but typically they are not going to give you any information to help you identify that problem. One other thing that comes up, typically speaking, I tend to see that audits that are prompted by employee complaints come with very, very short notice periods or no notice at all. The Department of Labor is not required by the regulations or by the Act to provide a lot of notice, and they typically don't.
Paul, how is an employer most likely to first learn that they're going to be subject to an audit? You said it's short notice or no notice. How do I find out if I'm an employer? How do I get that red flag initially? Almost always the same way, which is that you will get a notice of an audit from the Department of Labor. You'll actually get a letter, a form letter, so to speak. But the exception to that would be if a form letter has been sent to you and it didn't get sent to the right address or it didn't get sent to the right person's desk in your organization, sat in the mailroom too long, and you may find out when the Department of Labor investigator knocks on the door for the first day of the audit. But there's always an audit initiation letter sent. It just doesn't always make it into the right hands in time. You ever get a phone call or anything like that precedes those letters? What's your experience in that regard? I've not seen that often. It has happened rarely, but most of the time the audit letter is the initiating force that I've seen. Now, typically, some investigators at the DOL will handle those things differently. I think if they don't feel like they need the element of surprise because they feel like they have a hot button issue, then they may give you the courtesy of a phone call in advance. But typically, I often get the question too on dealing with these wage and hour audits: can we get an extension of time to get prepared for this audit? They're asking us to have a lot of information available, but they're only giving us 5 working days of notice. Can we get an extension? The answer to that is maybe. They do have provisions in place to allow for extensions of time, but they're not going to give you long extensions of time. At most, you're going to get a matter of a couple of business days, maybe on the far end, 5 extra business days to prepare for that audit. But I've had many requests for extensions get denied outright. The Department of Labor takes the position that you need to have these documents readily available within a few days of notice, and they're not going to give you much more time than that. So
let's get now kind of to the meat of this topic, which is, okay, so we've gotten an audit. We have some idea now about why we're being audited. We may be in a particularly targeted sector, or we may have an employee complaint. But what are we going to see? Typically, you're going to see four things in a wage and hour audit. In almost all audits, we have the same four things. Number one, which is the most time-consuming and exhaustive part of that process, is that you're going to have to produce records for the investigator to review. That production is going to be normally at your work site or at the work site that the DOL wants to audit, and they are going to ask you for a multitude of different kinds of documentary information. They're going to ask you for all your payroll records for a specific given time. They're going to ask you for time cards for that same period of time, job descriptions so they can evaluate whether or not employees actually are exempt or non-exempt as the way you've classified them. They'll ask you for policies and procedures regarding your payroll processes and practices, timekeeping payroll practices, other policies and procedures that may be relevant to whatever complaint that they've received. And then lastly, and this has been something that's been fairly common over the last 2 years, I have seen almost every DOL audit that I've dealt with in the last couple of years has come with a request for I-9 information. And so going back to that first slide that I talked about to begin with, and the dual, or not dual roles, but the multiple roles that the DOL plays in the administrative process, they are piggybacking wage and hour audits onto immigration audits and basically saying, while we're here, we're going to check your I-9s too. And I have seen employers with near perfect wage and hour practices who, at the end of the day, have no problems with the Fair Labor Standards Act, end up with an I-9 problem or an immigration audit problem that was really just an afterthought to the DOL investigation. But I would be prepared for that to be a part of any wage and hour audit that you may get if you happen to have the employee complaint or whatever the triggering mechanism might be. The second thing that you will see is that you will see a questioning of your employees. Basically, the DOL has the right, and they do this in every single investigation. They will want to talk to employees. They will. Yeah, Charlie, go ahead.
I was just going to say, when they're interviewing, are they interviewing employees on site?
Yes, absolutely.
How about after hours? Does that come up?
They do it both ways. They have both the option to interview employees at your premises during work hours, and they will make requests for that. Typically, the ones that they want to talk to at your premises and during work hours are going to be the management level employees that they want to ask questions about policies and procedures and actual application of the practices that you're telling the DOL that you're using. And then in addition to that, they have the right to, and they do, contact employees off work hours, outside of the workplace. They may get their contact information and call them at home, and they have the right to do that as well. And questions that we get about these interviews routinely are, number one, do we have the right to have our attorneys at these interviews? That's a great question and an important one. And you have the right as an employer to be represented by your counsel or by accountants or by other representatives at any process, at any part of this audit process, except the interview of non-management level employees. The DOL can and does talk to non-management level employees away from the ears of your counsel. And, of course, the reason for that is because they want to get the most straightforward and honest answers that they can get, and they feel like that if the attorney is there, the employee is less likely to be forthcoming.
Well, and what about, I understand I can't have my lawyer present when a non-management employee is being interviewed. What about another supervisor or an HR person? Can they sit in on rank and file employee interviews?
Well, the first answer to the question is you can always ask, and the investigator may allow it. However, the investigator is typically going to take the position that no one from the company is going to be permitted to sit in on those non-management level employee interviews. And there's case law and regulatory support for that. Now, of course, the difficulty from the employer's perspective on that is that employees often don't know the answers to some of these questions that they're being given or can't articulate the answers as well as they need to be, and sometimes there's some pretty damaging information that comes out of that that's erroneous information. And so we have to kind of be prepared to deal with that in step number 4, which we'll get to in just a minute. You will also see the actual investigation of the premises itself. The DOL investigator may ask for a tour of the plant, a tour of the office space, may want to see, as a practical matter, where the time clocks are, how much walking time is involved in a day-to-day operation for a group of employees. They may want to be shown around to the employees' break stations. They may want to be able to see where your Fair Labor Standards Act posters are put up so that they can make sure that you're complying with the record-keeping and posting requirements. And so there's plenty of opportunity for investigation as well. And then last, the findings and negotiations. After the audit is conducted, the DOL investigator will report back to you any problems that they've found and report to you any penalties that they may be willing to or preparing to propose as a result of the audit findings. And then you have an opportunity at that point to negotiate those issues short of litigation. And that's generally speaking what you can expect from a wage and hour audit.
Oh, we've talked a little bit about the audit, and that's obviously conducted by the Wage and Hour Division. What other trends have we seen in the last 6 to 12 months and that we're anticipating for 2012 in the way of lawsuits?
Yeah, and you know the main trend that we've seen when it comes to lawsuits, and this is something that started maybe 10 years ago, but is starting to grow exponentially over the last couple of years, is the concept of a collective action. And a collective action is, for lack of a better word, it's like a class action. It's a lawsuit that is filed by one individual or two individuals, a small number of individual named plaintiffs, on behalf of others who are similarly situated. And essentially what that means is a group of employees that has had a policy or a practice applied to them that they believe to be unlawful. So, for example, if I was not paying overtime on a group of employees that should otherwise be entitled to it, that group could bring a collective action against me as the employer and pursue their small claims in an aggregate sense. They could all join together and pursue their small claims together in one action, resulting in a much bigger action that where there's a significant amount of money and time involved. The reason to do that is to provide an economic incentive for the employees to pursue those small claims. Typically, if I had a claim worth $100 or $200 in uncompensated time, I wouldn't take the time and the expense necessary to pursue that action. But if they're grouped together with a bunch of other employees who may have similar claims, then it could be thousands or hundreds of thousands of dollars at issue, and certainly then the big plaintiff's attorneys will get involved and take notice, and they're certainly willing to do that. Collective actions end up being long, complicated, expensive pieces of litigation, and often they do result in attorney's fee awards to plaintiffs' attorneys in the hundreds of thousands of dollars for the amount of time spent over a couple of years on a collective action. Now, typically, after a named plaintiff files a collective action, the court will require us to give notice to everyone who is similarly situated to that named plaintiff and allow them the option to opt in to a collective action. And we may end up with hundreds or thousands of small claims aggregated together in one single lawsuit in front of a court. And one other thing I want to say about these is that while the collective actions that you may read about are typically huge collective actions with hundreds or thousands of employees, a collective action may be filed against a very small employer who only has a small number of employees. For example, I've got a collective action pending right now for an employer that only has 5 total employees. But a collective action can be filed on behalf of any number of similarly situated employees. And these have been, they've been fairly common over the last couple of years, and we think they will be increasingly common as more and more publicity for these things starts reaching the plaintiff's bar. and I think we'll see more of these going forward in 2012.
One of the points we're trying to make here is for 2012, the combination of a more active wage and hour division and having more resources combined with the growth of collective action, I think is fair to say that means we should be expecting more litigation, whether it's at the administrative agency stage or in collective actions in federal court. So what we wanted to spend the rest of our presentation on, we tried to identify particular issues that employers may be faced with in the next 12 months. And what Paul and I have done have really gone back and looked at what happened at the last half of 2011 and what sort of pronouncements the Wage and Hour Division is making in a way in which we hope to predict and kind of identify for you what are the kind of hot buttons you can expect in the next 12 months, and again in the hopes of doing some preventative work so you stay out of the crosshairs of the Wage and Hour Division. And number one on the hit parade for the end of last year and the beginning of 2012, I think, is the issue of independent contractors and whether or not employers have classified people who are independent contractors who are in fact should be treated as employees. You know, the obvious advantage for employers to classify people as independent contractors rather than employees is to avoid the obligation to withhold taxes, no obligation to pay overtime, those sorts of things. And the Wage and Hour Division has announced an initiative for 2012, and they're going to spend a lot of resources and a lot of energy on determining whether an employer has misclassified individuals as independent contractors when they are in fact employees and should be treated as employees. They're also working hand in hand, the Wage and Hour Division is working hand in hand with the IRS and some state regulatory agencies like state tax commissions or workers' compensation. And when the IRS or a state agency, a taxing agency or workers' compensation system determines someone is not an independent contractor and is in fact an employee, that agency may share that information and that determination with the Department of Labor, and you find yourself now dealing with the Department of Labor on that. Now, a couple of reasons why the Department of Labor has issued this initiative to really focus on misclassification of independent contractors. Their perception is that in this period of recession, a lot of employers are overusing independent contractors. You have employers during our recent recession that were unwilling to commit to regular employment, maybe didn't want to hire somebody full-time, pay the benefits, that sort of thing. So there's a perception that there was a misuse during the down economic period of independent contractors. The second point is if you go to the We Can Help section of the Wage and Hour website, you'll see that a lot of the We Can Help information is soliciting claims or complaints about people who have been classified as independent contractors who are not, in fact, independent contractors or should be classified as employees. So you're seeing a lot of effort by the Department of Labor to team up with other agencies to identify independent contractors, misclassification, as well as really soliciting through their own websites people to come forward. Now, we've got on our PowerPoint, these are common factors, but useful to remember what factors does the Department of Labor look at to determine if someone is an independent contractor or should be treated as an employee for purposes of wage and hour laws and overtime. Level of control is the big one, and they really focus on how a particular job is performed, the hours worked, who is choosing the methods, what level of supervision versus what level of independence. Obviously, the more control an employer exercises over an individual, the more likely the Department of Labor is to treat them as an employee rather than an independent contractor. They'll also look at how you are paying an individual for tasks performed. Are you paying based on a project by project basis, or are you paying based on hours or a set salary. Again, if you got a set salary or an hourly rate, you begin to look like an employee rather than an independent contractor. Duration of the relationship. The wage and hour division takes the position, look, the longer someone is performing the same tasks for you, the more likely it really is an employee-employer relationship rather than an independent contractor. What sort of special skills or experience? And another common question is asked, okay, how long have you been performing this work for that company or employer, and do you provide similar work to others? If it's a relatively short duration and you're providing similar services and skills to other entities, you're more likely to be classified as an independent contractor than an employee. And finally, what sort of investments has that individual made in terms of tools or electronics or facilities? If you're providing all that sort of investment and material to help me perform my work on your behalf, then I begin to look more like an employee. And keep in mind what are the consequences if the wage and hour division comes in and challenges you on the classification of an individual as an independent contractor and says, you know what, this individual is truly an employee. The consequences are significant. First of all, if I'm misclassified as an independent contractor, you're going to owe me for a regular rate of pay and overtime if I worked in excess of 40 hours during a work week. It may also cause me to claim I should have been included in your insurance plan, your 401k plan, and benefit plans all along because I, in fact, was an employee rather than an independent contractor. You also may face workers' compensation issues. But I think it is safe to say that independent contractor and classification of individuals as independent contractors is going to be a hot button during the next 12 months. A little bit different approach on the concept of joint employers. The Department of Labor and its Wage and Hour Division is also touching on and investigating issues about joint employers. And these are instances in which an employer contracts with another organization to provide services for the company. And we gave you some examples, an employer who contracts with a janitorial service or maybe a delivery or courier service, or a recent example case was cable installers for a cable service provider. This is where an employer goes out and contracts for specific services from an existing entity. And they tend to be almost generally subcontracting relationships. And much like the analysis of independent contractor, the questions on whether or not this individual working at your location or in tasks you have assigned to them, even if they're working for another company, who exercises that functional control? Who is assigning work? Who's scheduling it? What's the level of supervision? Is it project by project? And who's really responsible for hiring and firing? Now, we talked about in an independent contractor status issue, if I'm misclassified as an independent contractor, whether I'm really an employee, you may owe me for benefits, overtime, those sorts of things. If the Department of Labor finds I'm a joint employer, I'm jointly employed, and I feel like I've been denied benefits or overtime, I have the option of going against either of the joint employers. That's why that's a little bit different from independent contractor. Now, Paul, can we change a little bit? We've talked about independent contractor and joint employer. Let's move into some preparation for work, commuting, those sorts of issues. Do you see those as questions that employers are going to be faced with during 2012?
Right, absolutely. I mean, going back to the idea of what we talked about earlier about the collective action issue and the independent lawsuits issue, we've gone back and taken a look at the collective actions and the other lawsuits that have been filed over the last 6 months or a year, and the trends that we've seen in that type of litigation and what we expect to see more of going forward. And there are, again, kind of to emphasize on the point I made earlier, particularly with respect to these collective actions, what plaintiffs' attorneys are looking for are policies or practices that result in small amounts of time that should have been compensable or should have been overtime and affected a number of employees going forward, and that allows them to aggregate those claims into a bigger lawsuit that's worthy of their pursuit. And one of those kind of broad classifications of claims that we see are claims dealing with preparation for work. What kinds of activities are employers not paying their employees for, and more importantly, should they be paying those for that type of work? Are those activities compensable under the FLSA? And then more importantly, if they are compensable, do they result in overtime calculations that should be going on? So dealing with the idea of preparation for work, first I want to talk about the default rule just to give you some indication as to what the legal structure is out there. And all of these discussions are very fact-intensive. All of these will really depend on the actual circumstances on the ground in each of your offices or your facilities. But generally speaking, the default rule in the Fair Labor Standards Act, and particularly the Portal-to-Portal Act amendments to the FLSA, is that most preparatory work is not compensable under the default rule. The default rule says that walking, riding, or traveling to and from the actual place of employment is not compensable, and performing other activities that are preliminary or post-preliminary to principal activities are not compensable activities. But the FLSA is one of those laws in which the exceptions tend to swallow up the rule. So while the default rule is there, the courts that have interpreted those default rules over time, and particularly the DOL in its interpretation of the default rule going forward, has been that there are a lot of massive exceptions to that Portal-to-Portal Act default rule, and a lot of preliminary and post-preliminary activities are compensable under these exceptions. So the first exception is anything that is, quote, integral and indispensable to the employee's principal activities. It's one of the most unhelpful definitions I've ever seen. It doesn't have any intuitive meaning to me at all, but that's the language that the courts use. So if it's, for example, an integral and indispensable activity would be if I work in a meat processing plant and I have to don, which means to put on, and doff, which means to take off, protective gear before I can start my shift, that has been interpreted to be integral to my principal activities, which is working on the cutting line of a meat processing plant. Anything that is integral and indispensable is an exception to the default rule. A bigger exception is any agreement that the employee and the employer has entered into regarding preliminary and post-preliminary activities is going to be enforceable. So if you have a collective bargaining agreement, or even if I have a private agreement regarding what my compensation structure is going to be, if you have promised to pay me for those preliminary activities, you have to do it. It becomes a Fair Labor Standards Act issue when you promise to pay for something via policy or via agreement. And then finally, and this is a big rule that causes a lot of confusion, it's what we call the continuous workday rule. But once a workday begins, once an actual compensable activity has occurred, anything that happens after that is compensable going forward. So if, for example, in the continuous workday setting, if I were to, once I don my protective gear and my workday begins at that meat processing plant, if I take some of that gear off for a break and put it back on for after my break is over, all of that is going to be compensable, even if it was not compensable at the beginning of the day. So those three exceptions are major exceptions to the Portal-to-Portal Act rules, and there are scores and scores and scores of lawsuits interpreting these particular exceptions and how they should be applied. But generally what we want to do today is give you an overview of those issues so that you can prepare yourself to analyze your own environment and see if you have some potential liability on work preparation claims. Moving on to some specific examples of preliminary and post-preliminary work that has been found under the exceptions to be compensable. Donning and doffing of protective equipment I've told you about already. And I think that makes sense from an integral and indispensable test. However, there's even an exception to that exception. when you're just talking about the donning or doffing of uniforms or ordinary clothing, the courts have found that that is not compensable. And so you find that there is a lot of detailed analysis and a lot of differing opinions by different courts on whether or not something is integral and indispensable. And so there's been a distinction made, a pretty clear distinction, between clothing and uniforms on the one hand and protective equipment on the other hand. And these types of claims, donning and doffing of protective equipment, are really the first types of collective actions that we saw. Other types of things that we might see are inspections. If you're requiring employees to inspect a truck or equipment, those types of things before their shift begins, that's typically going to be preparatory work that needs to be compensated. Checking out tools and equipment, sanitizing the boots or sanitizing equipment is definitely going to be preliminary work that needs to be compensated. Interestingly enough, the new trend that we've seen recently is collective actions being filed by more traditional office environment type employees. So if you're requiring employees to boot up and shut down computers or other office systems, that might be compensable work that's preliminary to their actual shift time starting. And there have been a lot of those cases recently where collective actions have been certified based on what's traditionally been very minimal office-type work. Inventory, paperwork, those kinds of things. I've seen collective actions for waitresses and wait staff who are asked to sort silverware before they start their shift. Those types of things can also be preparation claims. Any other activity that's required by the employer prior to the scheduled shift time might end up being compensable work time and an overtime issue. And so you really need to be analyzing those and determining whether or not you've got some potential liability there. The next kind of main topic we want to talk about is the issue of travel time. This has been another issue that's been a common basis for collective actions in the last year or so, and will be again going forward in this year. Again, looking at that same default rule, walking, traveling to and from the actual place of employment is not typically compensable. That means ordinary commute time between home and work is not generally compensable work. So if I work in the same geographic location every day, my commute time is not ordinarily compensable, unless I do work during that commute. And so I could, for example, if I take cell phone calls while I'm driving to and from work, that will ultimately result in part of my commute being compensable. And it will start the continuous workday. Once I have a compensable activity, anything that happens after that is going to be compensable until my shift ends. So you need to have policies and procedures in place to prevent employees from doing work during their commute if you want to prevent this from happening. Then also other travel time issues that come up frequently. The example that I've seen in a couple of collective actions recently are the service technicians issues. A lot of times, employers that use service technicians will dispatch those employees from their homes directly to their first job site of the day. Those individuals take their trucks home, they take their tools home, they don't need to come report in to the main office before they go out to their first call. Instead, they leave directly from home and go to their first job site. So the question in that case is that ordinary commute time? Or is that drive time and that travel time going to be compensable? Generally, if we're sending them to a job site that is within a normal commuting area, within a set reasonable amount of time from their home, that's not going to be compensable any more than normal commuting time. But we've got to make sure we have dispatch programs in place that limit the amount of exposure they have to travel time, because it can very easily fall outside of that normal commuting area, and we end up with a collective action based on that kind of uncompensated time. Travel also has some particular regulations and peculiar rules that deal with one-day travel assignments and overnight travel assignments. So, for example, when we drive to and from if I were an Oklahoma City-based employee who drove to Tulsa for a seminar, my drive time might be compensable, and typically it would be on a one-day travel assignment. However, under the regulations, travel to and from the airport on a one-day assignment is for some reason treated as typical commute time. So a lot of detailed regulations here when it comes to one-day and overnight travel assignments that your HR staff really needs to have a good control of and make sure that we're not applying a practice or a policy to employees that we're asking to travel that may result in a collective action. And then kind of the last main topic that we've got that, again, is a frequent subject of collective actions is the concept of on-call time. On-call time can be compensable work or it can be non-compensable work. It depends upon the application of several factors that courts have determined over time that control whether or not we are receiving the predominant benefit of that on-call time or if the employee is receiving the predominant benefit of that on-call time. So the more flexibility that we give to our employees while they are on call, the more likely we are to fit under the scenario where the employee receives the predominant benefit of that time and therefore it's not compensable unless they're actually called back to work. Those factors are, number one, flexibility. We've got to allow them to effectively use their time. We've got to give them a reasonable amount of time to respond when a call is placed out to them. We've got to give them the technology that allows them to move to and from their homes while they're on call. If we don't provide a cell phone or a pager or some other avenue that can allow them to travel a little bit during their on-call time, we're really marrying them to their home phone, which takes away all that flexibility and creates a situation where they may end up being compensated for all the time that they've been on call. And when you start having someone who's on call for 24 or 48 hours straight, that can certainly be a very, very expensive process down the road. Giving the employees flexibility to trade on-call shifts is a good idea from a policy perspective. That's treated very favorably by courts when determining how much flexibility employees get on call. And then the frequency with which we call our on-call employees back. If we put people on call one weekend a month, but they are always called back 2 or 3 times during that weekend, the practical result of that is that they don't have any flexibility with their weekend. They don't get to use the predominant benefit of their time because they know they're going to be called back. So we really need to control how much time or how frequently we call those employees back on call. And we need to the extent we can, we need to limit the amount of location restrictions we put on those employees. If we tell them they have got to return to the job site within 15 minutes of a call, then we're putting a pretty limited geographic limitation on how far away they can get from their homes while they're on call. If the more of those that we place on them, the more likely a court is going to conclude that that wasn't really on-call time, but was truly entirely work time the entire time they were on call. So again, these are the frequent topics that we've seen in collective actions and lawsuits going forward, or that we expect to see going forward next year.
Okay, a couple things come to mind on the on-call issue, and on-call time. This is one example where I think increased technology and employers' access to increased technology actually works to their advantage. With the advent of more sophisticated smartphones, really, texting, all the different ways people can be on call but maintain maximum freedom. I guess that really, in the flexibility you're talking about, Paul, that increases the chances of us being able to say, yes, you're on call, but unless we actually need your services, that on-call time should not be compensated. Is that one advantage to increased sophistication in terms of electronic communication?
That's absolutely right. And the only caveat to that is technology provides the double-edged sword, because the more access we provide to our employees to their work-related resources, the more likely we are to actually have them engage in work while they are off the premises or off the clock. And so while it does help us with on-call time, it hurts us in the sense that there are also collective actions out there right now that we've seen some over the last few years, dealing with employees who are checking emails on a BlackBerry while they're at home. And so be cognizant of the fact that if we give our employees access at home or access away from the office to email and other systems, they may be using it. And if they're using that access, there's a good argument that they're performing work that may result in a request for compensation down the road. And it may be a good request. It may be that they are actually doing work.
Yeah, the practical problem employers have is when the employee is happy and pleased, you don't get the request for the payment. It's the dissatisfied employee or the employee on their way out the door that says, hey, you should have been paying me for this on-call. I had another question before we move to telecommuting for you, Paul. I guess there is also an overlap or issues where I'm on call and I get a directive to commute or travel in as a result of my on-call. So you've got both of those issues overlaying. I'm on call, but I can't perform my services from a remote position. You're telling me to get in my car and travel to my regular place of work. What happens in that example when I'm on call, but you're saying, hey, I need you back at the office?
Absolutely.
At travel time, what happens?
Right. So the question there is, if I am on call and I get a call and and a request to return to work, do I get the benefit then? Do I, the employer, get the benefit of the commuting rule? If I call you back to the office, is that going to be ordinary commute time, or do you get compensated at your regular rate for returning to work? Typically what I've seen employers do is compensate those on-call employees from the time that call gets placed. And so they typically factor in some travel time, and that may be as much as anything morale-based rather than a commuting issue. And this, like any of these, is really going to be fact-specific and dependent on the individual circumstances of each employer and how much travel time and how much drive time we're requesting these employees to do. But you're certainly right that there is an overlap of these two problems when we've got on-call situations.
But one of the new developments in the last year or two we've seen increasingly is the issue of telecommuting with the increase in sophistication of employers' electronic communication systems and their willingness or perhaps desire to have employees work off-site. We have a lot of employees who prefer to work off-site for convenience or efficiency or just a lifestyle choice. That's a growing number of our workforce is doing that. And in the context of sometimes medical conditions, we've used telecommuting, and employers have used telecommuting as a way to accommodate either temporary or perhaps permanent restrictions or limitations on individuals, and that's a very positive development. But I think it's important these days for employers to understand what are the wage and hour considerations if and when you decide to permit your employees or even encourage your employees to conduct work or perform tasks in some sort of telecommuting fashion. A couple things to keep in mind. First of all, what is the access and communication for non-exempt employees? Are they off the clock or on the clock when they're actually not communicating? Another problem with telecommunications we've seen with employers is if you're going to request or request an employee to perform tasks or assignments at satellite location or through telecommuting, how easy is it to actually oversee their quality and their performance? What are they actually doing? And then from a wage and hour standpoint, if I'm off premises and I'm performing tasks, remotely, how am I going to, or how you as an employer are going to accurately monitor and record the hours I'm actually performing? I mean, I'm at home. How do you know when I'm actually working? And that really takes us to, this is still an evolving problem, and we're probably identifying more problems than solutions, but here's the kind of solutions and suggestions we're developing for employers when you're wrestling around with telecommuting. First of all, if you have people who are non-exempt, that are entitled to overtime, have a very specific work schedule. If they're going to work at home or out of town or from another location, be very specific what their hours of work are. Number two, if you have someone who's non-exempt working on a remote or telecommuting basis, come up with a method that may be logging in and logging out of your electronic communication system, but create a mechanism or a system where you can record, or at least show your recording very specifically when I'm actively involved, and require me not only to work to a specific schedule, but place requirements on how and when I'm to log in and log out. And also stress, and this is true whether you're dealing with telecommuting and remote work or on premises, stress and enforce a no overtime without prior authority requirement. Now, that little check mark, because of the problems we've seen and the suggestions, a lot of times our employers, and I think this makes a lot of sense, are saying it's just not possible or practical to control non-exempt employees working remotely. So we're only going to permit telecommuting to exempt employees. And that's kind of sometimes a very practical result. Any observations on telecommuting, Paul, in addition to what we just talked about?
No, I think you're right. I mean, it's going to be one of those areas that's really going to explode with questions and concerns as time goes on, as more and more employers have both the technology and the will to implement telecommuting policies.
Let's close with really an explosion in retaliation claims. There has been an unprecedented increase of individuals bringing lawsuits against former employers, or the Department of Labor and its Wage and Hour Division bringing lawsuits against employers by former employees, claiming that the individual lost their job by virtue of exercising some rights under the FLSA. And what's happened, besides greater activity on the behalf of the Wage and Hour Division and private plaintiffs' attorneys, we've also seen a growth or expansion in the law in recognizing what sorts of activities are protected and might give rise to retaliation claims. And in the last 12 to 18 months, we've seen cases that say, look, if an employee merely asks questions or makes complaints to a supervisor, that becomes protected activity that they can claim a subsequent firing was in retaliation for. If an individual does nothing more than talks to an attorney or perhaps accesses the DOL website or a local Wage and Hour Division, that is protected activity. In other words, it's not limited to me filing a formal complaint. It can be something as preliminary as questioning a policy or practice by the employer when it comes to payroll or time records or overtime. It could be as little as me just seeking advice from the Department of Labor. It also can be an oral complaint. There was a recent Supreme Court decision that says, look, it does not have to be a written complaint. It doesn't have to be a complaint to the Department of Labor. It can be an oral complaint an individual employee makes, and if that employee is subsequently fired, they have the ability to claim that termination was in retaliation for that oral complaint. So, two things happening here. More active Wage and Hour Division and private attorneys willing to take retaliation claims, and a recognition under the law that's going to take a very expansive view of what can be the basis of retaliation claims. So I think, Paul, we can expect more retaliation claims in 2012. You agree?
Do.
Brad, that's it for the substance of what we wanted to cover. Can you take us home?
I sure can. Thanks, Charlie, and thank you, Paul. You've given us a lot of information and certainly quite a bit to think about. Before we close, I want to quickly remind you of a couple things. First, you'll be getting a follow-up survey sometime in the next few days. We really encourage you to respond to that survey so that we can continue to improve our webinars and keep hitting on those subjects that are of particular interest to you. And at the conclusion of that survey, you will be linked directly to the webinar resources page that will include answers for questions submitted throughout our presentation today. Also, an archived version of this webinar will be available later this afternoon on our website, In case you missed any part of today's presentation or if you want to go back and listen to it again, you're also welcome to share it with anyone else who might benefit from this information. Finally, EmployerLINC 2012, McAfee Taft's annual employment and employee benefit seminar is coming up pretty soon.
Brad, can I interrupt you, Brad? Is that picture, that's the Unabomber, right?
I'll let others make that judgment.
Okay, thanks.
This half-day information-packed seminar will be first held on April 3rd in Tulsa at the Renaissance Hotel and Convention Center. Then the following week on April 10th, we'll meet at the Cox Convention Center in downtown Oklahoma City. You can find out more information about the seminar and register on our website at www.McAfeeTaft.com/EmployerLINC2012. Again, I want to thank Charlie Plumb and Paul Ross for presenting today's webinar. And on behalf of the McAfee Taft Labor and Employment Group, we want to thank you for taking time out of your busy day to participate in this presentation. Have a great afternoon and happy Valentine's Day.